popular view because for one particular kind of protest, the protest filed at the what's now called the Government Accountability Office, the scope of a protest of another transaction was extremely limited. It's kind of protests are kind of a strange story to begin with. I mean, think of the private sector where if you're bidding on an effort with a customer and you lose, that you sue your customer. I mean, it doesn't really sound like a very good business strategy, but it happens in the federal government procurement system all the time. So protests have a strange. I'm going to get to answer your question in just a moment, but protests have kind of a strange origin. The Government Accountability Office, formerly called the General Accounting Office, was formed as a result of the Budget and Accounting Act of 1921, and along the way, by the 1930s, the GAO decided that it had authority to review contested bids of government contracts as part of its statutory authority to review the settlement of accounts. Now, if those two things don't sound exactly alike, well, they're not. And law review articles have been written saying that the GAO, assuming bid protest jurisdiction, had a dubious legal basis. So the whole GAO bid protest system, before it became statutory, was subject to question. However, very few people questioned it. Well, is that the only forum? What about going to court to protest an action? Well, in 1940, in the Perkins Steel case, the Supreme Court said a disappointed bidder had no standing to sue in federal court because the procurement statutes weren't there to benefit the bidder. They were there to regulate the way the government did its business. In 1946, Congress passed the Administrative Procedure Act. It was not until 25 years later that which provided for judicial review of agency actions. But it was not until 25 years later in the Scanwell case that U.S. district courts decided that under the Administrative Procedure Act, they had jurisdiction to review protest cases. So we had the GAO doing its administrative review of protests. And by the way, the GAO, under the Budget and Accounting Act, is not an executive branch agency. It's actually a congressional agency. So we had a congressional agency reviewing executive branch decisions. And then in 1970, we had district courts. Well, today the situation has changed somewhat. As far as the courts are concerned, there was an attempt to rationalize who had jurisdiction. Was it the Court of Claims or was it the district court? And finally, in 1996, Congress passed a statute that vested in the Court of Federal Claims exclusive jurisdiction to review pre-award bid protest and took that of procurement contracts and took that authority away from the district courts. That was supposed to bring uniformity because there are 94 district courts in this country. There's only one Court of Federal Claims. So the idea was decisions would now be consistent. Well, that's fine, Congress, except that you still have the GAO, a non-judicial forum for bid protests. GAO's dubious authority to engage in bid protest was changed in 1984 with the Competition and Contracting Act, which specifically vested statutory authority in GAO. That statutory authority, however, is not to engage in final decisions, but it's merely to recommend whether or not a contract should be canceled or a bid protest should be sustained. So there's a lot of strange background and uncertainty to all of this, which gets us to OTs. The issue of whether you could protest an other transaction to GAO, the same way you could protest a procurement contract, was pretty much known before OTs were ever created because there were other non-procurement agreements, namely grants, cooperative agreements, and cooperative research and development agreements that people had tried to protest to GAO. And GAO took the position, we don't have jurisdiction to review those particular instruments except under the circumstances where the agency should have been using a procurement contract instead of one of those instruments. So if you're using a non-procurement agreement correctly, GAO says we won't look beyond that threshold question. So that's the same rule that applied to other transactions when they were first protested. And the first protest case against another transaction at GAO came in 1995 with electronic conversion devices. It was a DARPA case which we prevailed on. But that's the basic rule at GAO. Now, the thing that got people focused on this issue was Oracle's protest of the Reen Cloud award of a cloud computing contract by the Defense Innovation Unit Experimental. And in that case, and by the way, that case is highlighted in the DoD Other Transaction Guide as a case study, which is basically a summary review of that case. What happened there was that DIU funded a program to take U.S. Transportation Command's
successful prototype.
Well, no. Well, it wasn't. The issue was that their storage had been damaged, and they wanted to take their data and transition it into cloud storage rather than physical location storage. And so they entered into this prototype project to understand whether they could do that. And it turned out to be successful, and they wanted to then have cloud services cloud computing provided as a service. That was viewed as the production aspect of this successful prototype project. However, the award of the production contract, cloud computing as a service, was not limited to U.S. Transportation Command, but it was a government-wide award that amounted to $950 million, potentially amounted to $950 million. And Oracle, which had declined to be a player at the prototype project level, protested, saying, if only we had known
there was $1 billion at stake.
There was $1 billion at stake, we would have been a player in this. And so GAO took that case up, and they said it met the threshold for them reviewing the case, and they went in and they examined what had happened, and they also interpreted the OT statutes in doing what they did. And Bill Greenwald, the staffer who was behind a lot of the recent OT legislation in the Senate Armed Services Committee, wrote an article in the magazine Breaking Defense, which absolutely excoriated GAO and that decision. I wrote an article published in the Government Contractor where I didn't excoriate GAO. I just pointed out that their decision had many flaws in it, including the fact that they announced what their approach to statutory construction was, and in fact, their approach was exactly the opposite of what they said that it was. They also ignored the fact that there had been 2 prior versions of follow-on production for OTs, neither of which had ever been used because they were too stilted and narrow, and GAO was basically pushing DoD back into something that Congress had already relieved it from by creating flexible authority. So between Bill's article and my article, I think GAO in more recent decisions has sort of gotten back on the ranch, and they're in their more traditional mode of looking at OTs. And there's a whole new story now about to what extent and which courts might get involved in OT protest. But I think we've sort of beaten this one enough for this particular session. Maybe we'll talk about court jurisdiction and OT some other time.
Well, thank you. If you want to learn about this topic or other topics regarding other transactions, please visit us at thestrategicinstitute.org.